Senator Rocky Adams, Senator Thayer,
Here.
Senator Yates, Representative Bridges, Representative Fraser Gordon, Representative Grossberg,
Here.
Representative Lewis, Co-Chair West.
Here.
We have a quorum.
First matter of business is approval of the minutes. Is there any additions or corrections to the minutes? Seeing none, is there a motion? Approval of the minutes. Is there a second?
Second.
Without objection, is so ordered. Please call the first regulation.
General Government Cabinet Auditor of Public 045 KAR 001040 with amendment.
This regulation is being amended to update regulatory references and the material incorporated by report formats conform to the regulatory basis of accounting and auditing standards. The staff suggested amendment amends various sections to add statutory citations and comply with the drafting requirements of KRS Chapter 13A.
Would you please identify yourself for the record?
Graham Gray, General Counsel for the Auditor of Public Accounts.
Is your green light on there?
Yes.
Okay, could you pull that a little closer, please? We always have these issues.
I'm Graham Gray. I'm General Counsel for APA.
I'm Farrah Petter, Assistant State Auditor.
Thank you. There is a staff amendment. Is there a motion for approval of the staff amendment? We have a second.
Second.
Without objection, it is so ordered. Any questions from members on this set of regs from the Auditor of Public Accounts? Seeing none, please call the next regulation.
Department for Local Government
Thank you.
109 KAR 17010.
This regulation establishes a form that a county attorney is required to file beginning on July 1st, 2023, relating to preparation of settlements under KRS 69370 and 64830. The staff suggested amendment amends Section 1 to specify the citation and the title of the form incorporated by reference, and Section 2 to add a URL where the material incorporated by reference may be found on the agency's website.
Would you please identify yourself for the record? Thank you. There is a staff amendment. Is there a motion for approval of staff amendment? We have a motion.
Second.
We have a second. Without objection, is so ordered. Any questions for DLG? Seeing none, please call the next regulation. Thank you.
Boards and Commissions, Board of Optometric Examiners 201 KAR 5055 with amendment.
201 KR 5005 amends to update definitions, eliminate barriers to establishing the doctor-patient relationship via telehealth, incorporate model telehealth language relating to jurisdictional concerns, and establish the manner in which doctors of optometry may utilize telehealth in the practice of optometry. The staff amendment amends various sections to comply with KRS Chapter 13A.
Would you please identify yourself for the record?
My name is Carolyn Munson.
My name is Christy LeMay, and I'm the Executive Director for the Kentucky Board of Optometric Examiners.
Thank you. There is a staff amendment. Is there a motion for approval of the staff amendment? Do we have a second?
Second.
Without objection, it is so ordered. Any questions for the Board of Optometric Examiners? Seeing none, please call the next regulation. Thank you.
Board of Nursing 201 KAR 2478 with amendment.
201 KR 2478 amends to authorize dialysis technicians to prepare and access central venous catheters if they have 6 months of training and experience regarding central venous catheters. The amended after comments version clarifies that a dialysis technician's scope of practice includes preparation of catheter ports, access, including connection and disconnection, and site care of the percutaneously or surgically inserted central venous catheters. The staff amendment amends various sections to comply with KRS Chapter 13A.
Would you please identify yourself for the record?
Yes, good afternoon. Jeff Prather, General Counsel, Kentucky Board of Nursing.
There is a staff amendment. Is there a motion for approval of the staff amendment? We have a motion. Do we have a second?
Second.
Senator Thayer, I'm glad you're here today with Senator Adams on the road. You're doing yeoman's work. We just expect that of you. Without objection, it is so ordered. Any questions for the Board of Nursing? Seeing none, please call the next regulation.
Thank you.
Tourism, Arts, and Heritage Cabinet, Department of Fish and Wildlife Resources, 301 KAR 1001, 301 KAR 222, both with amendments.
301-1001 establishes definitions for terms used in 301 KAR Chapter 1. The staff suggested amendment amends various sections to comply with KRS Chapter 13A.
3012-222 is being amended to expand and clarify definitions, change boat right, WMA, waterfowl hunting rules, replace a complicated formula-driven shot shell allowance with a simple 25 shell limit at boat right, ballard, and sloughs WMAs, limit boat access on boat right WMA from December 1 to January 31 to people participating in department-managed activities, clarify that the maximum distance party members may be apart is 75 feet at ballard and sloughs WMAs, add relevant language from 301 KAR 4020 and 301 KAR 4050 to allow those regulations to be repealed, remove specific date allowances at WMAs for special youth waterfowl seasons and allow for the special seasons pursuant to 301 KAR 221, change northern boundary of no hunting zone at Ballard WMA to remove reference to the now removed Dam 53, remove the requirement for the department to provide blinds and for hunters to hunt from blinds at South Shore WMA, and expand the section describing rules associated with department limited access waterfowl hunts. The staff suggested amendment amends various sections to comply with the drafting requirements of KRS Chapter 13A and make technical changes.
It would not be an administrative regs meeting without the Department of Fish and Wildlife. Thank you for coming. If you could identify yourselves for the record.
Commissioner Rich Storm.
Jenny Gilbert.
There are staff amendments. Is there a motion for approval of the staff amendments? Do we have a second? Without objection, it is so ordered. I see that you have material there in front of you, and it looks like you're serious. Do you need to provide us some information on these regs?
Not necessarily, but we had the funny papers with us, I guess.
I got you. Any questions for these fine people from Fish and Wildlife? Seeing none, please call next regulation. Thank you.
Thank you all.
Energy and Environment Cabinet, Department for Environmental Protection, 401 KAR 58040 with amendment.
401-58040 amends requirements for the control of asbestos emissions to revise definitions, cross-reference OSHA requirements for asbestos signage, and incorporate material by reference. The staff suggested amendment amends various sections to comply with KRS Chapter 13A.
Would you please identify yourself for the record?
Michael Kennedy, Director for the Division for Air Quality.
Thank you. There is a staff amendment. Is there a motion for approval of the staff amendment? Do we have a second?
Second.
Without objection, it is so ordered. Any questions for the Department for Environmental Protection? Seeing none, please call the next regulation. Thank you.
Justice and Public Safety, Department for Juvenile Justice, 505 KAR 1120, 505 KAR 1140, both with amendment.
505 KAR 1120 is amended to update the department's policies and procedures on health and safety services, including policies relating to definitions, restraints, and suicide prevention and intervention. 505 KAR 1140 is amended to update the department's policies and procedures on detention services, including policies relating to definitions, the delivery system, transportation, restraints, and isolation. The staff suggested amendment amends various sections and policies to delete definitions and policies that have been replaced by new emergency regulations filed by the department, to delete the requirement of having at least one female-only facility, to remove references to male youth in the procedures for high and low security detention facilities, and for clarity, consistency, and to comply with 13A drafting requirements.
Would you please identify yourself for the record?
Amy Barker, Assistant General Counsel here for DJJ.
Good afternoon. William Codell. Good afternoon.
There you go.
William Codell. I'm an attorney for the Department of Juvenile Justice.
Thank you. There are staff amendments. Is there a motion for approval of staff amendments? Is there a second? Without objection, it is so ordered. We're going to slow the bus down for a second here. These are some fairly big, in-depth changes. And we do have someone here to speak in opposition from the Department of Public Advocacy. So if you would just give us a brief overview of what we're doing here, the reason for the changes. I'm assuming the reason is us, the legislature. But if you could just briefly comment on what we're looking at here.
Yes, the most significant part of the changes are to meet legislative changes and to have non-lethal ability to help control the juvenile population. So we've modified definitions to allow that. We've taken out prohibitions to allow that. We've also modified the suicide policy to have a little more control and safety at the highest watch level. So those are the most prominent changes we've made.
I'm going to start with a question. Did we mandate these changes, or are they all just on your own related to a response to the riots that have occurred, or is it a mixture combination?
Initially, it was in response to some of the disturbances they've had at the facilities, because these were filed prior to the legislative change. Part of them were then essentially ratified by the legislative change, and we've made some adjustments based on differences in our operations and the legislation that came through.
Gotcha. I'm going to go ahead and open it up for questions, and then we'll have DPA up to speak in opposition. Any members need to ask a question or chime in here? Representative Bridges.
And thank you, Mr. Chair. I may be running the two regulations together, so if I am, please forgive me. But in the effort to separate the males and the females, how do you intend to address gender identity in this?
That's not expressly dealt with in the regulation, and fortunately that's not an issue that we've had come up subsequent to having separate facilities for female youth and male youth. That's an issue we would have to study. It's not included in this current regulation, so that would be something that I would have to approach DJJ leadership about, get some feedback, and then follow up with you. Apologize, I'm not really prepared to speak on that today.
No, I understand. I appreciate it. Just a thought that occurred to me when we make these efforts. But thank you, Mr. Chair.
You're welcome. Any other members? Okay, if we could now, Tim Arnold, if you're here to speak. When you're prepared, state your name for the record and proceed. I need you to pull that mic a little closer if you can. Green light. Not yet.
Oh, okay.
There you go.
All right, we're going. Usually I don't need a mic. My name is Tim Arnold. I am the Post-Trial Division Director at the Kentucky Department of Public Advocacy. I am here today to speak on specifically KR 505 KAR 140, and specifically the proposed policy 700.1 that's incorporated into that. This doesn't address many of the issues that have been mentioned previously in this testimony. The specific issue that this regulation presents for us is that the regulation, even after the staff amendment, does not require or give any procedure to have a plan to eventually require a regional system of juvenile detention, which is what the statutes require. So KRS 15A 305 has, since its adoption in 1998, required the DJJ have a regional juvenile detention system. And indeed, all of the detention centers are named regional juvenile detention centers. Recently, in the last session, Senate Bill 162, Section 6, Subpart 1, directs DJJ to return to a regional system as soon as practical. That was, because these changes were made prior to the legislative session, so obviously this body considered the fact of those changes and made it clear that they wish to have the system return to a regional system as soon as it can. There is a good reason for this.
regional system, all of the services that these youth are receiving, certainly services from our agency, but services from other agencies as well, are generally provided geographically. And having a system where there is no regionalization and so youth are spread out across the state creates significant burdens. For example, we're here in Franklin County. I'm a Franklin County attorney. If I wanted to go visit clients in I would be going to the Fayette County Detention Center prior to this change. That's about a 36-mile round trip from my office. Those youth from Franklin County are now in Breathitt and McCracken counties, which means that it is now a 712-mile round trip to visit all of these youth. That's not just my travel. That's also going to be the travel for the sheriffs who are required to take them to court. And so the effect of that has been that many of these youth are simply not going to court, that they're being brought in over Zoom or some other means that is not an effective. These are kids. They often don't understand the process to begin with. They need a lot of hand-holding and attention, and they're not getting that through this online process. And so, and indeed, in some instances, they can't even get to court because there's so many different places to have court that the detention facility can't get to all of the courts they need to get to, so some kids are delayed. The effect of this in practice is not merely that they're not receiving the legal services that they're entitled to or that the courts are not providing, able to process their cases as well as we might like, but it's actually increasing the population of DJJ because many of these instances you can't, so for example, there are 2 Todd County youth in the detention center. Would have been in Warren County, but now they're in Boyd County, so they are a 654-mile round trip from their home community. If they were to be released, how would they get home? The answer is somebody's going to have to take them, and the resources to get them home are not immediately available. Oftentimes, it's the sheriff who would take them. If the court was to release them, typically the court would want them in court so they can release them from court because their family members will be there, but they can't get to court because they're so far away the sheriff can't go get them. And so this is really having a very negative effect on the system. The regulation that's been promulgated continues to maintain the non-regional system and does not have any indication in it of any plan to return to a regional system. There's nothing in the regulation that says that until this, here's a process we're going to follow, or this is true until this date, and then after this date there's a new system. Nothing like that is included in the regulation. So in principle, this is a 7-year regulation that continues the non-regional system that's having significant impacts on our justice system and on my agency. Thank you very much. I appreciate your indulgence.
Okay, I'm going to have a question and a clarification for you real quick. So for all the members, and here in a second you can correct me if I'm wrong, okay? I think we're looking at 505 KAR 1.140. I think with this regulation, the department is basically re-upping their procedures manual and procedures for doing business. And your point is that the regionalization is not in the manual, and you would prefer that it be in the manual in the future. Am I summing it up correctly?
To a point. It's actually the language in the regulation specifically does not require regionalization. It says that DJJ shall place them where they feel it is best based on a variety of factors they identify. It requires that there be a high risk and a low risk set of institutions.
So it's not the fact that it's not in there. It goes a step further and sets up a program that is the opposite.
If they were to regionalize, they would be breaking the regulation as they are proposing it.
Okay. And any questions for DPA from any of the members? Okay. So if you could, the department, if you could respond to that.
Currently, the way it's written, and in this case, let me put my thoughts together here. I disagree a little bit with some of the statements made.
If you could pull that mic a little closer.
Sure.
I'm sorry.
We took out language that required a separate female facility so that wouldn't be a problem as DJJ works its way back toward the new legislation. You just can't wave a wand and say, we're back to where we were. Part of the difficulty is staffing levels. They have improved. They have to continue to improve at some of the facilities that are in markets where it's difficult to obtain staff because there's high-paying jobs in that area. Several of the city areas are like that, and we still have some difficulties with it. We also have to be primarily concerned with security. So they have the high level and the low level risks. So you're looking at having 3 different types of juvenile in a same facility based on what DPA is asking us to do. The facilities aren't able to separate the children basically in 6 divisions because you have to have male and female, high and low. So you've got 6 sets of juveniles you have to divide. So it's a process to get the security elements in place, plus there's some physical issues at some of the facilities. So this isn't the end of everything in this. This is a step toward the legislation, and DJJ's looking at how to manage the children at the facilities that exist.
So go ahead, you were.
No, that's fine.
Certainly. And I understand the citation that the Department of Public Advocacy is making, but that particular provision of policy does not prevent a regional system. What that particular provision of policy states is that in the regional system, DJJ has to retain the discretion on occasion with particular youth to move them to a different facility than where they would have gone in a regional facility. And DJJ needs that discretion for various reasons. For example, sometimes we'll get orders from the court saying that co-defendants have to be kept separated. You can't have 2 co-defendants. The court makes the determination communicating together, so we have to keep those 2 co-defendants separated. If they both went to the same facility in the regional system, that would be very difficult to enforce. We need that discretion to say we have a regional system, but this particular youth is going to go to a different facility for this specific reason. Same thing if a youth is very assaultive. Unfortunately, we do have some very violent young men and young women that commit assaults in our facilities, and we have to transfer them to a more secure facility. In the Department of Juvenile Justice, the Adair Juvenile Detention Center is our highest security facility. And we need that discretion. If a youth is very assaultive, if there's perhaps gang activity going on at a certain facility, we need that discretion for safety and security reasons to be able to separate youth. So we do have a regional system. I understand the Department of Public Advocacy's point about saying there is a provision of policy that goes against that, but that's simply an exception that's needed for safety and security reasons.
How many regions do we have?
Well, we have 7 facilities, and currently one of them is female only. And so basically we have 3 regions because the remaining 6 are high-level and low-level offenders for more severe offenses and lower-level offenses. And again, there's some discretion there. A low-level offender can earn their way into a higher-level offense facility.
I think you mean vice versa.
Well, if a offender in a low-level facility engages in assault at that facility, they're going to go to the higher-level facility.
And so Jefferson is coming back online, correct, at a certain point?
It is.
So that will be in that region?
Yes.
Will that be a new region, or will that be in an existing region?
I don't know that that's set in stone yet. I suspect that Jefferson will be a region all unto itself.
Right. Which would make sense, right, based on population.
Yes.
Any members have questions for the department right now? We're talking to DJJ. Any questions? So, Representative Frazier Gordon. Sorry, didn't see you.
And this isn't really directed toward one agency or the other, but I think the point that you brought up about the transportation costs and issue, that impacts our local county governments. And so I do think that is something that needs to be considered greatly because that ties up personnel, vehicle, gas. There is quite a bit of an expense to that. So I just wanted to make that comment.
Any other questions? I'm going to flip it back now to DPA if you would like to respond.
Thank you very much. So the regulation, the section that I'm referring to was before the staff amendment, Section J. I think that's now been promoted to Section I because I think Section H was deleted. But it says DJJ may determine and designate the detention center where a youth will be detained based on multiple factors such as safety, security, staffing needs, and the fluctuating number of youth at different locations. The sheriff or the jailer of the youth county shall transport the youth to the detention center designated by DJJ unless DJJ agrees to conduct the transport. It doesn't say region or anything in there. Like, that is the provision that is just, about where they go, and there's absolutely no reference to region. In fact, there's no reference to region in the entire document. And so it is not, I think it's simply incorrect to say this is a regional system today. It's not regional in practice. I can name whatever county, and if I have the data, I can tell you, in general, most of these kids are not in the region they used to be. And they, kids are shuffled around quite a bit. Jefferson County kids are in 6 of the 7 institutions. Every institution except McCracken. Fayette County kids are in 4 of the 7 institutions. Those are our 2 largest county. Kenton County kids are in 3 of the separate institutions and not in the one that is a mile from their office and a mile from the courthouse. Like, it is a very, very unregional system at the moment. And there's nothing in this regulation that sends us back to a regional system. Regionality is not mentioned at all.
Back to the department, is there a goal to get to the regionalization, more regionalization, I guess?
Certainly a goal to continue and as we expand Jefferson detention, because that's really kind of the genesis of a lot of these issues. Is previously Jefferson County was the one county in the state that did their own detention of youth, and that somewhat recently shifted over to the state. And so that was a lot to absorb and digest, a much higher number of youth thrown into the system. And the thing
to his point, though, I mean, if the statute clearly says you shall have regionalization, shouldn't it be written in the regs, and the first step be that child is going to the closest facility in the region? Shouldn't that be the default?
We have catchment areas, and it is a regional system currently. Sometimes it doesn't make sense for various reasons for the youth to go to the closest detention center where they're located. For example, youth in Bullitt County, once Jefferson is up and operating, Jefferson will probably be a catchment area all into its own, where only Jefferson County youth are going to go to that detention center, and they'll probably keep it filled up. You have youth in Bullitt County that'll probably have to go to Adair or Warren, even though Jefferson County is directly adjacent to the north. And right now in our regional system, counties with more than a few youth are going to have youth at 2 different facilities, no matter what, because we have a high-level facility and a low-level facility. And so if we have that system operating, which is what we have right now, and you get one keep separate order, then all of a sudden you have youth in 3 different facilities. So it's not surprising to me to hear that Fayette County has youth in 4 different facilities right now. But that doesn't mean we're not operating a regional system.
Gotcha. Representative Grossberg.
Wouldn't it be possible to somehow codify the mechanisms by which youth are distributed so that it doesn't at least appear as arbitrary as it is? I mean, you guys gave very clear examples of why you'd want to do it. Why isn't that in the regulation specifying a process by which the youth would be distributed elsewhere? Because the gentleman giving an example of the youth from Jefferson County being in 6 different facilities throughout the state, it's really hard for me to believe that that's due to an incident where you had 6 co-defendants and a court order to separate them into 6 different facilities.
That would probably be a combination of keep separate orders and also assaults going on, and safety and security reasons. But I agree with your point as far as it would be a goal in the future to perhaps write in the regulation what these catchment areas are going to be, so that it is more concrete and that it's something that we can all point to. Right now, we're in sort of a transition period where the legislature has provided certain funding to reopen a detention center in Jefferson County. So anything we wrote in a regulation right now would be subject to change as soon as we open up that facility in Jefferson County. But I agree with your point that that would be something that I would recommend to DJJ executive staff, that if we're going to have this regional system in these catchment areas, it's something that's certainly possible to put into a regulation.
Any other questions from members? Senator Adams.
Thank you, and I apologize for being tardy. This may have already been asked. But in this system that you're describing, are we confident in the capacity available for these regionals, particularly Jefferson County? Do we think that where we are as far as capacity, that we will reach it, or what are you expecting?
In all candor, that's a concern. It's a large number of youth, and retention and recruitment of staff to be able to maintain the ratio of youth to staff that we need to maintain is a concern. There's been recent efforts to address those concerns, including raising salaries for the people that work directly with the youth, the people doing the real work on the front lines, and that's been a dramatic help to help us. Because right now we can have pods that we can't open in a facility because we just don't have enough staff to staff it. So I think that's one of our number one areas to focus on is recruitment and retention of good staff, because that's going to continue to be an issue if we don't focus on that, is our capacity to take on the youth.
Any other questions? Is any member asking for any particular action on this? Seeing none, I'm not prepared to. The points of DPA are well taken by me. I truly understand what you're saying, and it's the job of DJJ to follow statute and do regionalization. I'm not prepared to make a deficiency motion this time on it, however, because of all the problems that DJJ has to face and work through and issues and so forth. So my opinion is that we clearly need to talk about this particular topic in Judiciary Committee further, and I'm going to make a recommendation that the chair take this topic up. It's a very important topic, but I think DJJ is going to need the help of the legislature to get to where they need to be on staffing and that sort of thing. Representative Grossberg.
Thank you, Mr. Chairman. I just wanted to concur with that and ask that we don't kick this can down the road indefinitely. I'm not comfortable with the regulatory changes, but I'm not comfortable doing nothing and waiting until after the Jefferson County facility is reopened to revisit it. So I'm going to ask that everyone in the meantime work, as the chairman had requested, on fixing this. I mean, there's no other simple way of putting it, because I know that some of the people who precede me on this committee have made jokes about Groundhog Day, and I hope that we're not going to have Groundhog Day on this. I really hope that next time we see you all, that there's something that is agreeable to regionalize. That was a tongue twister. The juvenile detention system. That's all I have to say on that. Thank you, Mr. Chairman.
Any other questions or comments? Seeing none, please call the next regulation. Thank you.
Community and Technical College System Fire Commission 739 KAR 2060 with amendment.
This regulation is being amended to correct a clerical error, remove the requirement that live fire instructors submit verification of IFSAC accredited Kentucky or IFSAC accredited reciprocity certification as a level 1 instructor if the applicant was previously certified as a level 1 instructor on or after September 6, 2003. Remove the requirement that live fire instructors in charge submit verification of IFSAC accredited Kentucky or IFSAC accredited reciprocity certification as a level 2 instructor if the applicant was previously certified as a level 2 instructor on or after June 28, 2011, and require live fire instructors in charge to successfully complete the Commission's live fire instructors in charge course and clarify the permitted scope of instruction of live fire instructors in charge by creating a new certification level for instructors who cannot teach acquired structure skills. The staff suggested amendment amends various sections to correct and add statutory citations and comply with the drafting requirements of KRS Chapter 13A.
I think this regulation has something to do with live fire instructors. Would you please identify yourself for the record?
Yes, Mark Rutter, Director of Training for Kentucky Fire Commission.
John Wood, outside counsel for the Kentucky Fire Commission.
Bruce Roberts, Deputy Director of the Fire Commission.
There is a staff amendment. Is there a motion for approval of the staff amendment? We have a motion. Do we have a second? Glad to have you back, Senator Adams. Without objection, it is so ordered. Any questions from members this set of regulations? Seeing none, please call the next regulation. Thank you.
Thank you.
Public Protection Cabinet, Horse Racing Commission, 810 KAR 7040 with agency amendment.
This regulation is being amended to create an opportunity to participate if the mayor's certificate of eligibility nomination was missed. Adjust the fees for a horse to late nominate within its 2-year-old year if the mare was not nominated during the calendar year of the breeding season. Allow for a 3-year-old to participate even if no sustaining payments were made as a 2-year-old, but keep the initial March 15th sustaining payment mandatory to encourage 2-year-old participation, and change the declaration starting fees to 0.5% of the total purses distributed or to be distributed for each race in which the horse is declared. The agency amendment amends Section 20 to correct a form title, Section 23 to update the addition dates for the forms and to incorporate by reference the application for late mare registration, and the material incorporated by reference to change the certification statement to say affirm instead of under the penalty of perjury, being duly sworn, depose, and say.
Would you please identify yourself for the record? Let's pull that mic or...
Okay.
There you go.
Hello, my name is Jennifer Wolsing. I'm the General Counsel of the Kentucky Horse Racing Commission.
Drew Connors, Director of Incentives and Development for the Kentucky Horse Racing Commission.
Thank you. There is an agency amendment. Are there any questions or discussion on the agency amendment? Senator Thayer.
Thank you, Mr. Chairman. Just on the overall reg, Drew, Jennifer, good to see you guys here today. Since this comes from the breeders' incentive legislation that I got passed 18 years ago, just want to hear from you about the change. Is this to help eligibility for horses that weren't nominated early? If they turn out that they can actually perform well, their owners or breeders can make them eligible later on for higher payments, sort of like the Breeders' Cup model?
Yeah, you hit the nail on the head. Basically, you know, when you set a deadline, people miss that deadline. And with this program, it's very similar. We're actually making it similar to the thoroughbred side of things as well. It gives these people an opportunity. When they miss the mayor's certificate of eligibility, they have to file that during the conception year from January 1 to December 31st. Then they actually go a full year and a half until that next yearling payment is due. So if they didn't make that initial nomination, this gives them an opportunity to get into the program, very similar to the thoroughbred side of thing, all the way up until their yearling year.
Very good. Members may not know this, but in the standard bred business, a lot of their purses in big races are funded by nomination payments stacked up with races all over the country. So I could see how they could easily miss a deadline when they're probably writing checks to various for charities, et cetera, around the country. And also, members should know that there'll be a third harness track opening up at Cumberland Run in Corbin in October. So in less than 5 years, we've gone from one harness track, the Red Mile in Lexington, to 3, Oak Grove and Christian County, and then the new track in Corbin. So I appreciate you taking good care of this program, and thank you for your answer today, guys. Thank you, Mr. Chairman.
So you're welcome. So along the lines of Senator Thayer's questioning, so theoretically this should increase purses somewhat?
Yes, somewhat from the nomination fees, but it's just more of an opportunity for these horses to be able to compete and to get into that program.
Gotcha. Any other questions? Seeing none, is there a motion for approval of the agency amendment?
So moved.
We have a motion. Do we have a second? With a second, it is so ordered. No objection. Please call the next regulation. Thank you.
Cabinet for Health and Family Services, Office of Inspector General, 900-5020 emergency, 900 KAR 6075 emergency, 900 KAR 14010 emergency, and 902 KAR 55015 emergency.
900-5020 emergency amends to allow care hospitals to convert existing beds to psychiatric beds if specified circumstances are met. 900 KAR 6075 emergency amends to grant non-substantive review status for CON applications wishing to so convert. The amended after comments version of these regulations changed the maximum number of beds that may be converted from 25 beds to 20% of the facility's acute care beds, up to a maximum of 25 beds.
900 KR 14010E,
amends to replace the reference to an assisted living community, long-term care facility, or state-owned or operated mental or psychiatric hospital with a health facility, health service, Medicaid waiver service, or psychiatric residential treatment facility in accordance with Senate Bill 43 from the 2023 regular session. 902 KR 5515E amends to designate tianeptine as a Schedule I controlled substance.
Would you please identify yourself for the record?
Sure. Adam Mather, Inspector General for the Cabinet for Health and Family Services.
Kara Daniel, Deputy Inspector General.
Thank you. There are no amendments. Any questions from members on this set of regulations? I got a quick question on the personal care visitor program. Could you just describe that in a little bit more detail, what we're actually doing?
Sure. It just expanded through, I think, Senator Meredith's legislation to a broader spectrum of healthcare facilities.
Gotcha. So is this COVID related, or is this just visitation in general?
It was initially COVID related. Now it's visitation in general with any communicable diseases.
Gotcha. Any other questions? Seeing none, please call the next regulation. Thank you.
Department for Community-Based Services, 922 KAR 1100.
922 KR 1100 updates provisions for public agency adoptions, including the referral of a child to the Kentucky Adoption Profile Exchange.
Committee will stand.
922-1330 updates provisions related to human trafficking to consider a report of human trafficking as a separate specific offense rather than including it under exploitation neglect, to include child sex and labor trafficking, and establish an alternative response procedure.
Would you please identify yourself for the record?
Good afternoon. My name is Laura Began, and I'm the Regulation Coordinator for the Department for Community-Based Services.
I'm Chelsea Harrod. I'm a specialist with the Child Protection Branch with the Division of Protection and Permanency.
Hello, I'm Veronica Sears. I'm the Adoption Services Branch Manager with the Division of Protection and Permanency.
Thank you. There are no amendments. Any members with questions on this set of regulations? Seeing none, thank you so much. That is the end of the agenda.
Thank you.
Thank you.
Short meeting today. I'm sure we'll have discussion on dates for next month.
We have scheduled July 13th, which is a Thursday at 1 p.m.
July 13th. If the committee will stand at ease here. That is the day after SLC, right? I think SLC ends the 12th, I think. Gotcha. So for everyone's information, that is the day after SLC, which ends the 12th. Any questions or concerns? Seeing none, this meeting's adjourned.